many companies, although this RM petition has been around for many, many years. It is a very unique method, and we thought we'd share with you some of our experiences with the RM petition, give you some education about it today. It will be a 1-hour program, and we're going to take questions at the end. In the upper right-hand corner or the right-hand portion of your screen, you'll see a place you could send questions. So please send them in, and we'll answer them at the end of the program. Masuda Funai is the oldest full-service international law firm. We focus on representing foreign investors into the United States, inbound work. And I've been at the Labor Board myself as a prosecuting attorney and as a hearing officer in election cases. I have prosecuted both unions as well as company. Ed, why don't you introduce yourself?
Well, thank you, Alan, and welcome to all of you who are listening in today. We are very confident that we're going to be able to share with you, as Alan mentioned, some new and unique information. Alan and I have been working together in several of these types of cases over the last several years. But let me tell you first, EMSI Consulting is my firm. It is a management consulting firm. We represent management only in all matters involving labor relations, employee relations, et cetera. I personally have been in the on this side of the equation of representing management for close to 30 years now. Formed the firm, however, about 25 years ago. We are a full-service, multilingual, multicultural, and nationwide consulting firm, again, representing management. And let's go on with the presentation.
Well, absolutely. As we know, unions come into companies two ways: through voluntary recognition by the company when the company has evidence that a majority of the employees want to have the union, or by an election. And some of you who are listening in today had union elections in which a majority of the employees who voted in favor of the union. The question is, how do we get rid of a union if we want to get rid of a union? And all of us really know about the RD petition, the decertification of the union, again, by a majority vote of the employees. But few of us really know about the RM petition, another alternative. And within the last 2 years, Ed and I have worked at a number of companies with RM petitions. And it's a very interesting, fascinating idea. We want to share with you one example of a client of ours in Indiana. It had an 88-year bargaining history with the Teamsters Union. And the Teamsters Union was very strong with this company for many years. But the company came to me totally fed up with the union. And it was having the feeling that its employees were also pretty much fed up with the union, with the business agent that was coming to the offices. What I then did was I called Ed, and I introduced Ed to the owners, and the owners then gave Ed some free rein within the company. What did you find, Ed?
Well, we first of all established what the goals were. They were certainly going to be following their legal obligation to renegotiate a contract, but anticipated kind of maybe a tough bargaining session. But when I first arrived and discussed their situation, and then later began to interface, be introduced and interface with the employees, we started finding out some things about the relationship the union had with these particular employees. You know, the visits to the company by the new business representative were frequent, but they were also somewhat slanted. Employees started talking about how the union, when they filed grievances, for example, seemed to favor certain employees versus others. And so we began to discover that there were the seeds and the roots for dissatisfaction with the current representation by the union. Again, remember, this went back many years. Increased poor performance by some workers that was being sanctioned to some degree by the union, and that seemed to upset some of their co-workers. Ironically enough, the union had recently increased the dues that employees were paying, and had put a poster in the union bulletin board on the plant floor. And the employees were concerned about what was going to happen, especially with health care and costs and so forth in the upcoming negotiations. So the initial thing was to begin to identify some of the questions and issues on the floor.
Now, this company had a human resource function by its CFO, but it was not a sophisticated human resource function. So we decided to make Ed our human resource department, our human resource consultant, and introduce him to the company's employees as our new human resource consultant. This was a way to increase the human resource department's impact. And through that, what were you able to discover, Ed?
Well, as I mentioned earlier, we began to communicate with the employees, obviously being aware of the fact that there are certain limitations imposed by the contract, but legally communicate with them, and began to, as I said, find out some of the specifics of the dissatisfaction that many of the employees were increasingly openly expressing about the representation of the union. So we began to hear from, we began to hear from employees about individual anecdotal examples and so forth, and I would make notes and share those with you so that you could analyze it and take it from there.
Yes, and that's where the lawyer came into force here, because we then were able to look at the important NLRB precedents and to really analyze whether or not the union was vulnerable to a decertification drive to decertify the union, or whether or not the company should file a petition to have an election to get rid of the union. That's the RM procedure, what the company should do, how vulnerable the union was. And as Ed and the other supervisors and the owners were talking to employees, they were collecting information from the employees. They were collecting statements that employees made about themselves and the union. They were collecting information about what employees said about other employees. They were collecting information from other supervisors, those supervisors talking to other employees. And we found that all of that evidence can be presented to the government.
Yeah, I just want to make a comment that when we say collecting information, I know that may sound a little bit let's say over the limits of what the law would allow. We're very careful to collect information or to gather information in a legal way, and basically it's triggered by employees' own comments, but then we sort of follow up on that or inquire about them, or feedback we were getting from the floor from supervisors or things of that nature. So yes, information is collected, but not in the sense of soliciting it in an illegal fashion.
Yeah, correct. It's very subtly done. Again, companies, supervisors, human resource consultants can be sponges. They cannot encourage, threaten, do all those things that are violations of the law, but you can be sponges. You can then receive information. We can then analyze information. And that's what we did. So we then filed a government form called a petition, an RM petition. We'll show you an example. But we also attached to that form important evidence, which we then presented to the regional director. And that evidence was in the form of legal affidavits given by Ed, given by some of the supervisors. We then decided to create a campaign and have the campaign. Tell us, Ed, about that campaign and what was really important about that campaign.
Well, the campaign prior to NLRB election is a series of informational meetings that we conduct with employees with the specific target of informing them about things that they may not have known. You'd be surprised how many people, even though they've been in unions forever, have never ever questioned where, for example, their union dues money goes to. And there are, of course, documents that are attainable that from the government, the Department of Labor, that show the union's financial status. We talked about the things that the company does over and above and beyond what they see in the contract, and we basically educate employees about the voting procedures and union's track records and so forth in order to get them to think about the opportunity to finally be union-free. Also, a campaign involves selling the company, as it were, presenting the company's point of view, presenting their, their message to them as to what would be life without a union. Again, always maintaining a, being concerned about the legalities of what can and can't be said.
And this was the result. It's an actual government document, a certification of results. It's created by the government 7 days after the election takes place, and it certifies the results of the election. And this document says that a majority of the valid ballots were counted, and that a majority of the employees no longer want to be represented by the union. So this is the company's goal when they want to be union-free. What can the union do? The union has to wait a whole year to come back and try to reorganize the employees. Many times they will not come back because the employees have spoken. We've given free choice to the employees through the election process. So this is what you want to have. Now what we're going to do is have a poll for you to fill out and tell us in your mind why your company would want to be non-union. And as you vote, we'll be able to tally the results and share them with you. Yeah, those results are not surprising at all to me. Yes, go ahead, Ed.
Well, it's interesting, Ellen, as I see the results coming in, we're seeing that things like, apparently the number one is to avoid wasteful, divisive grievances. I've certainly have seen this in my many years in the business, how unions in the workplace create the divisive nature. I see that some people are also voting for the ability to reduce costs, of course. That is a factor in union versus non-union settings. Studies have proven that. Flexibility in decision making, being able to take, make business decisions without them being encumbered by strict and maybe out-of-date seniority rules, et cetera. So it seems to follow the trend that we've seen in our experience out.
Yeah, especially the flexibility in decision making. That is a constant complaint I get from companies. Well, the time to act is now. Ed, when you went to the company in Indiana, when did you get there?
We actually started approximately 9 months, or a little over 9 months, before the contract expired, which I know you're going to be explaining here in a few minutes as to why that's such a key date, but gave us enough time to establish that relationship with employees, and as we said before, successfully allow them, the employees, and the company to become union-free.
Yes, and as you can see from the slide, if a contract expires on February 29th, 2012, there's 2 opportunities for a company to file this government petition called the RM Petition. And the first time is after the expiration of the contract, so that would be after February 29th, 2012. But also, under the Labor Board's rules, a company can file the petition during what's called the window period. And the window period is 60 to 90 days before the contract expires. In this situation, it would be between December 1 and December 30th. Anytime during that period of time, the company can file the RM petition. Now, we know that listening in today are a number of healthcare institutions. The window period for healthcare institutions is 90 to 120 days. There are three options that companies have when they want to end union representation. And we're going to focus today on the RM petition, but let's first look at the other two options and the advantages and disadvantages of those two options. The latest statistics, and I'll share those with you, for the last 12 months nationwide at the NLRB, there were over 1,300 elections. But to show you how infrequently this process is, of those 1,300 elections, only 270 were decertification elections, and only 58 were RM petitions. Only 58 were elections for RM petitions, elections in which companies filed to get rid of the union, for an election for the employees to decide whether or not to get rid of the union. We believe the RM petition is the best option for companies, the most doable, and the least risky for unfair labor practices. Why, Ed, do you think there are so few RM petitions?
Alan, I think that the reason why there are few RM petitions, and when I travel across the country, I usually try to make a point of stopping by the regional offices of the National Labor Relations Board in whatever city I'm in, and look through their records, through their dockets, they call them, to see how many RM petitions are filed. And so I'm not surprised that you came up with this number. I think, frankly, the main reason is because most people don't know that they have the option. They've never heard of it. I've talked to many companies who have asked me, well, what is an RM petition, or how does it work? And of course, that's what we're here to explain. But I think that that's the primary factor. If they're not aware of it, they don't know that it's there for them. So I would classify that as the primary reason why there's so few.
What many companies decide to do is to withdraw recognition. The problem with withdrawal recognition is that it will almost automatically be challenged by the union. How does the union do that? They file an unfair labor practice charge against the company, and you're involved in litigation. And litigation, which will be expensive, time-consuming, and can go many steps within the labor board and the court system. What happens with the withdrawal of recognition is that the company has heard things from employees and decides to send a letter to the union saying that we are hereby withdrawing recognition from the union. Now, as you know, there are two types of obligations, legal relationships that companies have with unions. The first is obvious, the contractual obligation. But underlying that contractual obligation, and at all times, whether there's a contract or not, there's a recognitional obligation, an obligation to recognize and bargain with the union. What the withdrawal of recognition does is take away that recognitional right. So if you're halfway through a contract, you get rid of that recognitional right, that recognitional obligation, the contract ends. And companies feel totally free at that time to make any changes they want. And since they don't have an obligation to recognize and bargain with the union, they can make those changes without talking to the union, without getting the union's consent. This is quite dangerous. Of course, many companies would shoot themselves in the foot if they started reducing wages immediately after withdrawing recognition. They would only get the employees angry at them and perhaps spur a union campaign or the union filing a ULTs. However, there are many changes that companies want to make and do make after withdrawal of recognition. And the biggest example in this economy is health insurance, and changing the health insurance plan, changing the health insurance deductibility, the coverage, all those things need to be bargained with the union. In 2001, the Labor Board came out with a very important case in which the Labor Board decided to discourage withdrawals of recognition and to encourage elections, because after all, the whole theory of the Labor Board is free choice by the employees in a secret ballot election. So the Labor Board ruled that the burden of proof is on the company to prove that they have actually lost the support of a majority of the employees. Actually lost is a very high burden. It means that more than 50% of the employees have indicated that they no longer want to be represented by the union. Now, this actual loss of support has to be supported by objective evidence. And the best type of objective evidence, obviously, are signatures of employees. And for example, a list signed by the employees with all the employees' signatures, and at the top it would say, we no longer want to be represented by the union. Of course, the company cannot encourage that list, cannot threaten employees to get that list, so it's very difficult to get that list. There's other indications that companies use. For example, oral statements made by employees to supervisors, and management can rely upon those statements and then withdraw recognition. Again, the union will challenge that. And the best way the union can challenge that is by having its own list of employee signatures from a majority of employees saying that they do represent and do want the union to represent them. The other is to have the company take a poll of employees. This poll must be done by secret ballot. The secret ballot is not conducted by the government, but could be conducted by a clergy person, by a local mayor, politician. But also, companies have to tell the employees the purpose of this poll. And the purpose is to determine whether or not the employees still want the union to represent them. So therefore, it's very difficult to get results from such a poll because it's very out in the open and because employees are afraid to vote for that. And of course, the company cannot encourage employees, they cannot misinform employees about this whole process. So this is very dangerous for companies. And as you can see, the implications of the danger is that the Labor Board will rule that everyone should return back to the status quo before the company withdrew recognition. What that means is that if there has been any change in insurance benefits, they have to be reversed. If there's been any changes in work rules and benefits, wages, hours of work, they all have to be reversed. And that can be very expensive, and that includes interest. Most importantly, the company can order the company to recognize and bargain with the union. So this is very dangerous, as we said, and of course the attorney's fees involved are very high to represent a company. Ed, what is your experience with withdrawals of recognition?
Well, as you said, legally it's a much higher threshold than what we'll be describing when we get to the issue of RMs as a better option. It's also difficult, apart from the legal, is because it involves, again, employees exposing themselves. In order for co-workers to secure the, because you mentioned that the company cannot actively participate or promote that or be involved in the gathering of signatures. It involves people signing a document that's likely to float around the plant floor or the cafeteria or whatever, and other people, including pro-union employees, finding out who is supporting the idea of getting rid of the union, and it could lead to friction. So just numerically, the fact that you need more than 50% to actually have the take the initiative to sign a document makes it legally more difficult, and I mean more difficult on the floor. And as you mentioned, it's legally more difficult to prove to the government that it was done without management taint.
So rather than a withdrawal of recognition, many companies hire consultants to have a decertification drive. And Ed has been involved in those. I've been involved in those decertification drives. Again, this is dangerous, and we'll explain the advantages and disadvantages. Like a withdrawal of recognition, or like an RM petition, the RD petition, this is the government form, has to be filed either after the contract expires or during the window period 60 to 90 days before the contract expires. This is a petition filed by employees. So at the top of this document that is filed along with the government petition is a list of employee signatures. And at the top is usually the statement, we no longer want to have the union represent us. This is attached then to the government petition. The regional director looks at this and then will order an election to take place. Now what's fascinating about an RD petition is that it's similar to the representation petition. all the employees need is 30% of their fellow workers to sign their list to support the petition to have an election. But as you may know from the literature and your own experiences, many unions will not file their own petition for an election unless they have 70, 80, 90% support. The reason for that is that our experience and statistics, studies have shown that the minute petitions are filed, the union starts losing support. So they won't file their petition for an election until they have, as I said, 70, 80, 90% support. Employees don't know that. They may get together, get 30% of themselves together and file a petition, and then they will start losing support. Also, companies cannot solicit signatures, call employees into their offices, as one famous case had it, and ask them to sign a petition. It has to be all employee-driven, which really puts employees on the spot because other employees, pro-union employees, as Ed just said, can see that they signed the petition against the union. As I said, the Labor Board will investigate, may well hold a hearing as to who can vote and who cannot vote in the election, and will schedule an election. And a campaign will take place. Ed, what's your experience with campaigns for decertifications?
Again, from an employee standpoint, it takes the initiative of typically a small handful of people to convince and persuade their co-workers to sign it, and then actually it takes one of them to physically visit the local office of the National Labor Relations Board and file that form. So there's a lot more exposure. However, not being a lawyer, but certainly having had the experience, I found that if in fact employees do take that initiative and do it, the government, the National Labor Relations Board, tends to look at that in a little more favorable light because it is employee driven. But by its very nature, that makes it a little harder to put into action because it is dependent on the employees gathering the signatures and knowing what the rights are, where the NLRB office is, filing it, etc. I've also had an interesting experience where employees who have tried to file RD petitions have reported back that the government often asks them many questions and basically interrogates them to find out how did they even know how to do this and so forth. So it's a kind of an intimidating process for many employees to take that initiative. But if they do, it is it's very strong evidence that the employees themselves want to seek out an election.
Yeah, and you said during campaigns, union use fear as their weapon.
Absolutely. Once a petition is filed, then in this particular case, as is the case in the RM petition too, the unions really, their only tactic is to try to scare employees into keeping the union in by threatening to or expressing to them how they will probably lose their vacation or their holidays or their health insurance will drop or their wages will be dropped or people can be fired indiscriminately. It's the only weapon that a union has during an attempt by its own members to try to be rid of them.
So let's get to the meat of our presentation, the RM petition. And as Ed said early on, many companies do not even know that this RM petition actually exists, but here is the actual copy of a government form called the petition. And as you can see, the very first box is for the petition to be filed by the union. It's an RC petition. The second box is the RM petition, which is filed by the company, employer petition it's called. The third is the RD petition, which we just mentioned. We also mentioned earlier on that there were 58 elections during the last 12 months nationwide. Of those elections, the company won 46 and the union won only 12. That's the total reverse, if not more, of the percentages when it comes to a representation election. For unions filing petitions for elections, unions are winning upwards of 61% of elections now. Here we have 46 of 58 elections won by companies. But it's very important to get the whole petition process correct. Again, what has to be filed with the government is this government form along with what the government calls objective evidence. What is that objective evidence? That's what we're going to be talking about. The RM petition can be filed during the window period or after the expiration of the contract. Now, of course, as we've said, there's a presumption by the government that the union represents a majority of the employees. That's even in the case of our Indiana company, where the union came in 88 years ago. There's way more than 100% turnover from 88 years ago. Even with some turnover, there's still a presumption of majority support. But what's very interesting about the NLRB is that the standard for withdrawal of recognition was actually lost support. Here, it's a much lower standard. It's good faith, reasonable uncertainty. A real legal mouthful, don't you think, Ed? Good faith, reasonable uncertainty. So it has to be good faith, which means no unfair labor practices at the same time at the company. It has to be reasonable, and it has to be evidence that you believe that the union no longer has support of the majority of the employees. But what's really difficult, and what the real challenge is that there is no bright line rule that the Labor Board has issued as to what is a good faith reasonable uncertainty. This is a case-by-case analysis, and this is an analysis done by all of the different regional directors all over the country. More than 35 different regional directors are looking at the objective evidence and making decisions based upon court rulings, based upon their own intuition and their own beliefs as to what is sufficient to order an election. And different regional directors have different views of what's a good faith, reasonable uncertainty. Certainly, good faith, reasonable uncertainty can be shown in the same ways we've talked about before. For example, a list of employee signatures would be the best way of showing that, because what we want to show to the regional director is something that reasonably indicates that employees are opposed to the union. It can't just be speculation. For example, an employee coming up to Ed and saying, gee, I think the majority of employees will vote against the union. That's speculation. Or, gee, the union hasn't been here for 6 months. Probably they don't care about us. We don't care about them. That's speculation. It really is a continuum of opposition to the union. It's a continuum of what regional directors will consider. And as I said, the best is probably a list of employee signatures over a statement that says we no longer want to be represented by the union. But it doesn't have to be that, and that's what's really great here, and that's what makes it really different than the decertification petition. The only thing that works for a decertification petition, as you know, Ed, is this list of signatures by 30% or more. Where for the RM petition, the objective evidence are secret affidavits given by Ed, given by supervisors about what they heard employees say. That's rank hearsay, but yet that's a reasonable uncertainty, and the board is required to take affidavits with hearsay. That's amazing from a legal standpoint, but if you're going to an election where employees have a free choice in a secret ballot, it kind of makes sense that the board will allow affidavits with hearsay information. Well, the board will get the petition, the government form, plus the affidavits prepared by your attorney, plus statements, maybe letters sent by the employees, created by the employees. And again, none of this is shared with the union. This is all internal investigation by the government, not subject to subpoena, not subject to challenge by the union, unless the union alleges that there were unusual circumstances. In other words, supervisors threatening employees to state their opposition to the union. In that case, the labor board will investigate. But again, the result may well be that a majority of employees will vote against the union. Tell us, Ed, about the special case that the Labor Board issued more than 20 years ago that allows you special rights, company special rights during a campaign.
Okay. Well, first of all, to mention about this concept called reasonable uncertainty and what it takes. As Alan mentioned, statements by your supervisors can be the basis for which a successful RM petition can be filed and an election triggered. We all know that people talk in workplaces, and so when we begin to interview managers and supervisors, something that is completely within our right to do, we start hearing about the fact that potentially some of their workers have indicated dissatisfaction with the union. So the statement of a supervisor who has heard these things on the shop floor or in the cafeteria or in the workplace and other places in the workplace can be enough to trigger that. But what Ellen was referring to is that once a petition is filed, and we get into, again, a campaign mode where we start sharing with employees, the advantages of being union-free and so forth. As I mentioned earlier, a union's primary counterattack is going to be the use of fear. Oh, they're going to take this away from you, or they're going to reduce your wages or fire you. But we did find a legal precedent by which a company engaged in a campaign after filing an RM petition can legally tell the employees that those fear tactics are bogus, because the company can say, we can't promise you any benefits or improvements if you vote the union out. And we're not threatening to take anything away from you if you vote the union out, but we can tell you that you will remain the same. You will keep the things you have or equal to. And that case that's referred to as the LSID case allows a company to actually issue even up to a written guarantee to employees prior to voting, saying, don't believe in the fear tactics. We have no intention, and we will not take away any of the current benefits you have if you decide to vote to become non-union. It's a very powerful tool.
And as you said, and especially with the Indiana company, those employees had no idea about the government process, about the election process. So a big part of your campaign was just simple education, and also education about the secret ballot, that their votes would be secret. The government agent would be coming to the company and holding that election. And that, I think you said, was really key to having the employees vote against the union.
Absolutely. It gave them a level of comfort that may not have existed under the options that we've already covered, the RD petition where they have to physically sign some sort of a document that might or might not get in the hands of the union and union co-workers or union sympathizers. In this particular case, again, it's company-driven, and then ultimately the secret ballot is the way that this is resolved.
And the secrecy of the employees' names are always kept inviolate. So, Ed, what do we have to lose?
Well, I keep telling companies that they really have nothing to lose in filing this. Obviously, there are several considerations to be taken into account. But what I mean by having nothing to lose is that even if filing an RM petition does not result in the company becoming or the workforce becoming a non-union, well, then you basically go back to the bargaining table and continue to meet your obligation to bargain in good faith without any additional types of obligations other than what you've always had. However, there are some other interesting advantages, is that by filing the RM petition, you have then the legal door open to be able to talk to employees about your position on the matter, the advantages of union-free. You can talk to them about how you treat your non-union employees and what benefits they might enjoy that the union employees don't have. So it really opens up the door legally to be able to educate. We also would educate employees at that point, if we hadn't already, about the RD option, et cetera. And so even if the regional director decides not to accept the evidence presented by the attorney in support of an RM petition, the door has been opened, or as they say, the bell has been rung, And employees then might take the initiative afterwards to ask about the other alternatives, which therefore could lead to an RD or a withdrawal of recognition.
So timing is really critical because we talk about filing the petition within the window period, which is 60 to 90 days, December 1 to December 30th. If there's pre-planning and all the government petition, the affidavits are prepared before December 1, the attorney can file the petition on December 1. The regional director will look at it, may well dismiss the petition on December 2nd, but you're in the facility on December 1, the minute that petition is filed, and you're telling the employees a petition has filed because the company wants to give employees the free right to exercise their secret ballot right to decide whether or not to have the union to continue to represent them. And then the next day, the regional director can dismiss the petition, but then what you say to the employees?
Has already registered with them, has already informed them exactly. The value of this option is that it legally allows you to open up the dialogue. Most people, when asked, are probably under the impression, and pretty much rightly so in many cases, unless they do it right, that you can't talk about decertifying a union, or you can't talk about getting rid of a union. And under normal circumstances, there are legal limitations on it. But if a petition has been filed by management, an RM petition, it legally opens up the door for dialogue.
Can you also blame the union for having the regional director dismiss the charge?
Of course. Anytime a union tries to take away an employee's right to vote or in somehow or another impede their rights, their legal rights, that certainly becomes even more evidence for employees looking into the idea of why is this union against the idea of us having a right to a secret ballot election.
And what happens if an employee comes to you and says, okay, the RM petition was dismissed, but we want to get rid of the union? What can you say?
Well, if an employee asks that type of direct question, they're entitled to an answer. And my answer would be, there are other legal options. I might share with them information that the government itself presents from their own NLRB webpage. I might direct them to the NLRB office and say, listen, inquire there about what your options are under, how an RD works or so forth. Employees who ask a question are entitled to a legal answer, and we're very careful as to what we say, but it does lead sometimes to them on their own exploring the RD option or getting more than 50% of the people to sign that they don't want the union, and of course that opens it up for withdrawal of recognition.
Of course. And as we talked about, the negotiations may well be different once the RM petition is filed, and even if it's dismissed or even if the union wins the election and negotiations continue, things are going to be different. And of course, the union can take tougher stands at the bargaining table. They can have more union visits. We hate to use the word harass. The union would say that they are just implementing the contract and gathering information about the contract's implementation. I've also seen situations, not really in RM petitions, but in representation petitions when unions want to represent employees. I've seen situations where unions allegedly have contacted OSHA or the Department of Labor for investigations. Also, there needs to be pre-planning because there are implications for your health insurance plan. The union plan will end, so the company will want to get a new health insurance plan. There's also withdrawal liability for the multi-employer pension plans. Those plans are underfunded, and the company is responsible for a portion of the underfunding. Again, this underfunding is calculated every year. Some years it's higher than others, but with pre-planning, the company may want to pay some of that withdrawal liability to get out of the yoke of the union. So what should you do now? You really have to find out what those magic words are. And those magic words show the dissatisfaction. You also have to get a commitment from management at all levels to be union-free. It really takes the commitment of management to want to be part of the process, to go through the vulnerability analysis, how vulnerable the union is and go through the process. We thought we'd ask you a poll, what you see in your facility among your employees as to whether or not the union is vulnerable. And please take a moment to fill this out. Tell us what you think you see in your company. What do you think of those results, Ed?
I think that they're very reflective of what we've seen in the real world. Yeah, when people start feeling that the union is just there to collect dues and nobody's attending their union meetings, or nobody actually pulls out the contract every time there's a dispute, but rather once they have more dialogue with HR or with the company or with their supervisors, all of these are the kinds of things that would indicate vulnerability. I just want to go back to one phrase that I know you and I use a lot, Alan, and you referred earlier to what are the, quote, magic words. As Alan mentioned, there are certainly, with filing an RM, there are different levels. The stronger your case, obviously, the better. But, you know, the magic word that we refer to is, and I asked this when I first arrived on the scene with doing these vulnerability studies, initial studies, is, you know, has anybody ever just expressed total dissatisfaction with the union? Words like, gee, I wish we could get rid of this union, or I wonder how the process is, or is there anything we can do to be rid of this union, or can we, you know, be union free? Those would be obviously the higher threshold magic words, if you were. But as was indicated earlier, even statements like just dissatisfaction with the union, these guys don't do anything for us, we never see them, I place a call into the business agent and they never come out here, or I filed a grievance and they failed to process it. Those kinds of evidence that employees are dissatisfied with the union representation and have expressed it are what we refer to as the magic words.
So what else should you be doing? Obviously then proactively engaging human resources, supervisors, consultants, and your attorney. And what we mean by proactively engaging them is getting that human resource manager out of their office. And it never ceases to surprise me in some factories that I visit that the human resource manager is in their office with the door closed. And it's very important to engage them and to show that the company is an alternative. Human resources is an alternative to the union. What do we mean by engaging supervisors? That means training them in the process, asking them what they would think about being non-union. And you'll hear from them the whole issue of flexibility in operating their departments, getting the consultants and attorneys together so that the supervisors, with the guidance of the consultant or a consultant coming in, will then start these persuader activities. What do we mean by persuader activities?
Well, as we indicate here, building support for the company, communicating to employees what the company does over and above what they might think is contained in the contract, that maybe they have the opinion that, well, this is what the union got us. So talking about some of the benefits of the company, being much more involved, being much more engaged with them, obviously. In terms of building opposition to the union, well, you know, if the union is raising the dues or failing to file grievances, and people want to talk about that, you know, they're entitled to do so, to share with them information, again, factual, legal information about the union. And then looking for those key indicators that, you know, this is the key as initially is to begin to see, have those, any level of those magic words been already uttered in the workplace, and we can take that and try to move forward towards the filing of the RM.
Yeah, and what's really key is what you can say to employees. And under the Labor Act, and many companies don't realize this, companies and supervisors have free speech under Section 8C of the Labor Act. And I always talk about free speech as an acronym. The union is our foe, F-O-E, facts. You can give your opinions, and you could give your experiences, the experiences of your friends and family members. Obviously, you cannot use TIPS, which is the other acronym that you well know of, threats, interrogation, promises, and surveillance. So what else do you need to do? You need to start creating a non-union environment. Many companies are very good at having an employee relations department where the employee relations professionals are out on the plant floor determining what every issue is and solving them. So it really creates a union-free mindset. You can start building trust. There's a very interesting labor board case called electromation that you may well be aware of, where companies can create employee committees. And these committees can be created even in a unionized environment. And it's a way for employees to have input, and they don't have to go to the union for that. Add employee opinion surveys is something that you do. Why and when do you use them?
Well, the value of conducting an internal employee opinion survey, number one is that these surveys are, by their nature, they're anonymous, and therefore people feel free to express themselves. In drafting up the survey instrument or the questionnaire that we use, and we do this obviously with a lot of management participation, we want to target certain things that we know will be of interest not only to employees but also to management. And so in addition to covering things like communications and safety and equipment and management and policies and so forth, we often give, these surveys also allow people to sort of just freely write some commentary in addition to that. And again, by the anonymous nature of the survey, this has often led to us receiving comments about the union, about the relationship of employees with the union, and therefore going from there towards more dialogue with them about that subject, and has led to ultimately the ability to file RM petitions and move the company towards becoming union-free. So employee opinion surveys are an excellent trigger point and an excellent vehicle by which we can begin to get the dialogue started. And I'll just make one more comment. If a union, and I've had this happen, basically is opposed to the survey even being conducted, once again, that's something that tends to work against them, because employees are by nature, I think, wanting to express themselves. And again, we have to work closely with the attorneys so that these surveys don't violate any of the contractual obligations, or any of the aspects of the labor law.
And that's what I was going to mention. Opinion surveys are totally lawful under the Labor Act if the questions are lawful questions. And as you know, you cannot interrogate employees about their support for the union or the support of other employees for the union. You cannot solicit grievances by asking employees their problems with the implied promise that they will be solved. But opinion surveys can be specially written, subtly written to get that type of information. And what's really key, and Ed was showing me a result of a survey earlier this week, are those general comments where employees just on their own will say negative things about the union. So as we sum up, what is your action plan? What should you as professionals be doing at your companies? And we want to propose these 4 things for you as you go back to your offices, as you look at your employees and talk to your managers the next several days. And obviously look at your overall goal. What is going on at your company? Every company is very different. Every company has a different culture. The relationships with the unions may be very positive, and you may not want to get rid of the union, or you may want to be union-free. It's very something that needs to be analyzed, discussed, considered. You also have to decide how much management is risk-averse. And I work with a number of companies where management just does not want to take any risk at all. And they have to understand what they are risk-averse about and what they're risk-averse not about. And that, of course, leads to the commitment. I've been in situations where some company managers are very pro moving ahead with a non-union drive. Others are not. I've been in situations where the union is coming into a company, and some managers don't want to fight the union, and some managers do. So it's really a matter of commitment, leadership, within the management team to make sure that everyone is buying in and is on the same page. And this is the importance of education from your consultant, from the attorney, to explain the different options, the different risks, the advantages and disadvantages. But what's really important is what Ed will talk about, which are the next two items.
Well, once your company has made, as Ellen said, a commitment, and you want to explore this, again, very legal option which is available to you, then typically we come in and help you to conduct that preliminary analysis of the union vulnerability, even prior to hitting the floor or talking to supervisors or whatever, just simply with an internal management group to determine, is there enough for us to move forward on ultimately, a program leading towards an RM. And then, of course, once that decision has been made, if we feel that there is enough, if the company feels that there is enough, the magic words have been said, then we determine a strategy, and we obviously implement it with the advice of the consultant or the participation of the consultant and the advice of the lawyer, and a lot of company participation. So we hope that this has been very helpful to you and informative. Obviously, these types of informational seminars or presentations are intended to be kind of general, and we look forward to hearing from you and answering your questions much more in detail as it relates to your particular situation. So I know Alan has a few more, but from my standpoint, I thank you all for listening, and look forward to hearing from you.
Well, Ed, we do have a couple questions. So one question that came in is, how soon after a contract expires can a company file an RM petition?
Well, it's more of a legal question, but I'll let you go ahead and think that's what's the legalities on filing once the contract is expired.
Well, the day after the contract expires, you can file an RM petition. But what's really interesting, and as you know, as the listeners know, and as you know, Ed, the unions want to have companies sign new contracts before the old contract expires. And you cannot file an RM petition while there is a contract in place. That's a contract bar.
We had a case, I'm sorry, Alan, we had a case recently where, yes, absolutely, the contract expired at midnight on the given day, and the next day the petition was filed. However, I just want to make the differentiation that you can't file a petition until after the contract expired, but you can begin the process, and obviously need to begin the process well in advance.
And that's why the window period is so important, because if you wait until later on, you miss the window period, you may well have reached a new contract before you are able to file the RM petition. The other question I see coming in is, can you file an RM petition while negotiations are taking place? Again, that's a good legal question. The answer is absolutely. You can file the employees can file an RD petition while negotiations are taking place. The company can file an RM petition during negotiations. Your obligation to recognize and bargain continues until there is an election. Well, I see we're out of time. We really thank you all for listening in. If you want to have more information about us, I'll share with you our website. Mine is www.masudafunai.com. And of course, the last page, those are our phone numbers. Ed, what is your website?
So our webpage is www.emsiconsulting.com. All one word, emsiconsulting.com.
So thank you very much. Have a great day.
Thank you.